Judge.
Morning.
This is the matter of Maricopa County Libertarian Party versus Maricopa County et al. CV 2021-002205. Counsel for the plaintiff, would you state your appearance, please?
Good morning, Judge. Michael Kilsky appearing on behalf of the plaintiff, Maricopa County Libertarian Party. Its chairman, Brandon Slayton, is on this virtual appearance as well, Judge.
All right, very good. Thank you and welcome. Welcome, Mr. Slayton. And counsel for the defendants?
Emily Kreger from the Maricopa County Attorney's Office on behalf of the Maricopa County defendants.
All right, thank you. And for the proposed interveners, Arizona Republican Party? Mr. Culloden, if you'd just take yourself off mute.
I'm sorry. Your Honor, Alexander Culloden and Brian Blem on behalf of proposed amicus, Arizona Republican Party.
All right, thank you. This is a time set. Is there anyone else that needs to make an appearance? All right, very good. I'm sorry, Mr. Kielski?
I said I don't believe so, Judge.
All right, very good. Thank you. Let me just do a sound check to make sure everyone is able to hear us. Can the clerk assign for today? Can you hear us?
Yes, I can.
All right, thank you. And don't know, did anyone order a quarter today?
No, Judge, we're good with FTR.
All right, very good. All right, this is a time set for a return hearing on the order to show cause application. We met last week. The county requested the opportunity to talk to the plaintiff to determine whether there was an out-of-court resolution. And if not, then we would come back today and talk about our path forward. Ms. Kreger, do you want to start us off about where things are with the county?
Thank you, Your Honor. Our office did have conversations with the representatives for the plaintiff. Unfortunately, we were not able to reach a resolution. Although we believe that there is no basis for these claims, and additionally, they are moot. As you may recall, at the last hearing, our office somehow had not received a notice of the hearing. So Mr. LaRue appeared as soon as he was aware of it, but we had not had a conversation with our client beforehand. We've since learned and have shared with the plaintiff that the actual audit, what's occurring at McTack, has been completed and was completed the day before our last hearing. So the request for injunctive relief at this point is moot. Additionally, the request that this court issue some sort of criminal declaration is improper, and notwithstanding all those, it's our belief that the basis for the claims that the audits had occurred are audits pursuant to Arizona statute is incorrect. That's not what occurred. And those audits occurred, and hand count audit occurred after the election pursuant to statute and within the requirements and the timelines that occurred. They occurred on October 16th, November 18th, and November 4th, respectively. So it's our intention to file a motion to dismiss. We've shared that with plaintiff's counsel, and unfortunately we were not able to reach a resolution. So it's our request for a timeline for filing that dispositive motion before we discuss any other scheduling that may be necessary in this case.
All right. Mr. Kielski?
Well, Judge, you participated in our previous virtual meeting in this, and if you recall, Judge, you may remember that the county explicitly said we're wrong, there is no audit. You're hearing today that, in fact, there were audits and they were completed. So, Judge, first of all, I just want to point that out. I think the county continues in its practice of being, and I'm going to put it as politely as I can be, deceptive. As documented in plaintiff's complaint and in its exhibits, the county has conducted multiple election audits. They last time we were here, they claimed there were no audits, and now they're saying, well, Judge, there were audits, but they're done. And as documented in plaintiff's complaint, the county publicly asserted that the political parties would partake in the process. Last Wednesday, counsel for the county told the court that the county was not actually conducting an audit, claimed to have not even known of the hearing, though the county defendants were served a notice of said hearing 6 days prior. On Thursday, Judge, I spoke with counsel for defendants, and the county promised they would clear all this confusion up. They would give me the scope of work document, rather not the draft that we had obtained, but the actual scope of work document, which would clarify the issues and would clearly show that the county is right and we're wrong, and therefore we would likely be willing to dismiss. On Friday, counsel for the county contacted plaintiff's counsel again and said, well, I'm still working on getting that statement of work, and once you have that, the scope of work, and once you have that, you will clearly see that you just need to dismiss. And again, plaintiff said, well, if that is clear, then we would certainly review that and consider that. And on Sunday, I received an email from the counsel for the county saying, well, since you didn't promise you were going to dismiss as soon as you got these documents, we're not going to give you these documents. And so, Judge, we are exactly where we were last time. I told the court at that time that I was concerned that the county was just continuing its delay tactics and its continuing practice of really just being nothing less than deceptive, making public pronouncements of one kind, and then telling the court on the record different things, and now going back on what they told the court, telling the plaintiff certain things, and then going back on that promise. Judge, the issues here are as simple as this. The draft statement of work, the draft scope of work that we've included in our exhibits made clear, and we have not had any reason to, nobody from the county's told us that wasn't correct, that among the things that were included in this audit that wasn't an audit were, for example, a logic and accuracy test. The statutes and the rules that have the force of law in Arizona clearly state that the political parties have an oversight responsibility and specifically calls out that issue of logic and accuracy test. And again, it goes far deeper than that, Judge. The county, again, just looking at the face of our complaint, looking at the pleadings that we've provided, and Judge, if I may also say, and again, I want to thank amicus counsel for their pleadings as well, as laid out very well in their proposed brief. Again, the laws are explicit. The political parties provide a critical political party observation / oversight function to all the functions of the county election department when it comes to election and election equipment. And the county is trying to basically be disingenuous. They're telling things to the court, and they're telling things to the plaintiff in this case, and they're saying what we believe upon information and belief, contradictory things in their litigation involving the Arizona Senate. In the litigation involving the Arizona Senate, we believe that they've been telling the Senate they can't provide, they can't comply with the Senate subpoena because they're doing these audits. And in this litigation, they originally told the court there weren't any audits. Now they're admitting that there are audits, but now they're saying, well, we don't get the oversight that the statutes and the rules that have the force of law require the political parties to have. Judge, again, on the face of the pleadings, I asked the court to issue the injunction and the declarative relief that we asked. And I want to urge the court further to pay attention to this. The county now has argued it's moot, and again, I warned the court last time we were here that the county is likely to pull that. And the reality is, Judge, it is not moot. Since the relief requested asked the court to find that the county's audit was illegal and thus a nullity. Moreover, even if the county is arguing that this case is now moot, since the deed is done, the court should apply the capable of repetition yet evading review mootness exception. Supreme Court has carved out that exception for cases that are capable of repetition yet evading review. In other words, if the issues may arise again and will often or always face timing challenges, courts should not dismiss such cases for mootness and may continue to hear the litigation. So again, Judge, we are standing by our complaint. The county, despite multiple promises that they were going to provide us the proof that would show that we're wrong, has reneged those promises, and now the county is asking for yet again more time to stretch this out and to essentially increase the strength of their quote unquote mootness argument that they that I predicted they would raise last time, that they're raising today, Judge. And again, they're just going through these motions, and they're telling things to the public at large about what they've done in this election audit and who was invited and who was supposed to perform functions, and then they've gone back on that, and they're trying to get away with things that are in clear violation of the law. We never asked the court to declare that the county had committed crimes. We simply pointed the criminal sanction potential out to the court to let the court know how serious it is, and that the failure to comply with the Arizona Secretary of State elections manual as approved by the Secretary of State and adopted as a rule and has the force effective law, does have criminal sanctions for those participants, including the county officers, who fail to comply with the law. And again, it's pointing that out for the purpose of seriousness, not for the purpose of having this court essentially hold these individuals criminally liable. So, Judge, we need to proceed. The defendants have done nothing but hand-waving and trying to delay this court. We asked for in the injunctive relief. We asked the court to rule on the pleadings presented, and we asked the court to grant the amicus motion so the court can also consider the amicus brief and the clearly described statutory framework that even better explains the issues for the court.
All right, very good. So, Ms. Krager, do you have any objection to the status of the Republican Party as an amicus?
We take no position on that, Your Honor.
All right, I'm going to grant the motion to allow the Republican Party to serve as amicus curiae in this matter, and I will consider their brief. I'm not going to issue any ruling today. I don't see any emergency basis to grant any type of temporary relief at this point. The sticking point for me is whether there are factual disputes, whether we need some process for addressing any factual disagreements before we get to a final resolution. I hear the plaintiffs saying this is an audit, what the county has been doing pursuant to the statute, it's an audit. I hear the defendants saying this is not an audit. Are we all working off of the same facts and just coming to different legal conclusions, or are there factual issues that we need to address? I just don't know how I get to a determination on that issue on a motion to dismiss without understanding the facts a little better. What's your perspective, Mr. Kielski?
Well, Judge, if the county defendants wish to dispute the facts that we've alleged in our complaint, then they are free to do so. And as I want to point out again and emphasize, because this is critical, they tried to do that last time we were in the virtual hearing, Judge, last week on Wednesday. They tried to say, well, no, it's not an audit. And you've heard today that the attorney for the defendants is saying, well, no, it's actually an audit. So that was the only factual dispute that they essentially set forth last week. Now they've said, well, no, that would, it in fact is an audit. So again, if the county wishes to dispute any of our factual allegations, they should speak up now. Otherwise, I think the court should proceed, as we suggested last week, to rule on the pleadings. And, if the county insists, they should have a reasonable but now much briefer amount of time to respond to our pleadings if they want to file as a motion to dismiss or a summary judgment motion, whatever they want to do. But, Judge, we just need to get to the point where the court can rule on the pleadings, because I don't believe there's any factual disputes. The events that we've laid out in our complaint as the factual background of the mystery are the events that took place. Again, I won't speak. Yeah, I won't speak for the county, but if they believe that we've said something that's untrue in terms of the factual basis, that now's the time for them to speak up.
Ms. Krieger?
Well, Your Honor, I do think this is a legal issue. This is at issue is whether or not the audit of the machinery that has taken place in February of this year is are the statutorily required pre and post logic and accuracy testing in 16449 and the hand count audit required in 16602. Those already took place, and as the plaintiffs know, because they participated in the hand count audit process. So in our opinion, and I mean, the fact is that everything the county's done has been done publicly. As this court, I'm sure, is aware, we've had multiple lawsuits, all of which were unsuccessful, related to the 2020 election in Maricopa County. All of this was done with video cameras available to the public and numerous other participants in what occurred in the audit. So, but at issue here is whether or not this falls into the statutory required ones, which is the position the county has always taken that they are not. This is an audit of the machinery. We've never kept it a secret. This has all been done publicly, and our position has been consistent. So I do not think that there are significant factual issues that are in dispute that would preclude the court from ruling on this. And we would just request to have, this court may be aware, we have another oral argument in another election-related case on Thursday of this week that we're preparing for. So we'd like we prefer until next Friday to have time to file our motion to dismiss with the court.
So next Friday being the first Friday of March?
That's correct.
All right.
And Judge,
I believe that's within 20 days after the initial application. I don't have that in front of me. Given all of the litigation going on, I'll give you until that first Friday in March to file that proceeding. I believe it's March 5th, but I don't have my calendar right in front of me. Can someone confirm, is that March 5th?
That is, Your Honor.
Okay.
And Judge, just for the record, again, we would urge the court to set a much shorter timeline. Again, Judge, the last week we had a lot of hand waving and asking for more time. This is why the court reset last week to this week, and again now the county is again asking for more time. I understand that the court senses that there is no urgency. But Judge, the issue here is that the county is proceeding to make multiple public pronouncements about what their audit concluded and what their audit was. And again, it's part of they have evaded the oversight of the political parties. They have kept us out, and they're using the results of their supposed audit for all kinds of purposes. And so that the additional time delay before the court can consider the defendant's responses is again works an injustice and works against the interests of the political parties, specifically plaintiffs and now amicus as well. So, Judge, I would urge the court to set a much shorter timeline for them. I urged the court last week to give the defendants 2 days, 3 days to file their brief and give us a day to file a reply. I would urge the court to do that here. Give them 2 or 3 days, give us a day to file a reply, because there are no factual issues in dispute, and the court can rule on the pleadings. And they just, if they're so confident about their position, if they're so clear about where they're at, it should not take them that long to simply point to the statutes and the elections procedures manual and say, look, you know, the plaintiffs are wrong, and here's why they're wrong, and then the court can take that into consideration. I don't see how they need literally 10 calendar days to get this done.
All right, I appreciate all of that. I've taken that all into consideration. The date for their filing is still next Friday, March 5th. Mr. Kielski, how much time do you request to get your response, or I guess reply? Well, it would be a response to the motion to dismiss. How much time would you need for that?
Well, Judge, I would ask until the Tuesday. That would be the 9th. So I would ask for two court days, March 9th, Tuesday, by the end of the day.
All right. And then Ms. Krager, Thursday sufficient for reply?
Yes, Your Honor, that's fine.
All right. And then the following week, we will set up a argument. Megan, what have we got for early the following week?
For how long?
I'll set it for an hour. I don't know if we'll need that, but I'll give both parties the opportunity to have a half hour for their arguments.
And you want it early in the week?
Please.
We could do Monday the 15th at 9:30.
Monday the 15th at 9:30?
Judge, I have a jury trial that has been delayed for almost a year because of COVID on that day. I'm available Tuesday, the 16th in the afternoon, if that works for you.
All right. Do we have that available, Megan?
Yes, we could do the 16th at 1:30.
That would work for us.
All right, very good. Ms. Krager, does that work for you?
It does, thank you.
All right, very good. Is there anything else that we need to discuss today? Mr. Kielski?
Oh, Judge, I think I put on the record what we needed to tell the court, and Judge, I do thank you for your very careful attention to the issues here.
All right, very good. Thank you. Ms. Krager, anything else today?
Nothing further, Your Honor, thank you.
All right, thank you all. Have a good day now.
Thank you, Your Honor.
Thank you.